Hello and welcome to Aging Matters. This is a show that is provided by and sponsored by the Berks County Area Agency on Aging. My name is Ann Barlet. I'm Public Advocacy and Outreach Manager for the agency. Our show today is on power of attorney, wills, and living wills. My guest today is Robert Bob Kreitz, who is an elder law attorney here in Berks County. I want to thank you, Bob, for being here and taking the time out of your schedule to really help us understand a little bit more about these areas of power of attorney, living wills, and wills.
My pleasure, Ann.
Understanding and enacting the power of attorney responsibilities, as well as understanding wills, living wills, and the enforcement of that is something that can be quite confusing, misunderstood, or just not clear, I guess. So I'm so glad we're going to talk about that today. So hopefully we can help folks out there understand the differences and when they're in effect and if I need them and how do I go about doing it. So I want to start right in because it's a meaty topic, and I would like to start with the power of attorney.
Okay.
So I guess let's start with the basic. What is that?
Okay. A power of attorney, Ann, is a document whereby one individual designates someone else to serve as their agent. Now, most of the time, the power of attorneys that we're speaking of, and I assume we'll be speaking about this evening, is a general power of attorney. But there are also specific power of attorneys. And if you decide you're tired of winter weather and want to move to Florida, and you sell your home and need to be in Florida before settlement, you could designate someone like myself as a specific power of attorney only to do that one duty. And then once that duty is performed and finished, then that power of attorney would end. But again, I think what we're going to talk about today are the general powers of attorney.
Right, so that example was a specific time frame and a temporary kind of thing, whereas, yes, I'm looking at somebody who's saying, in my future,
yes,
I may need somebody to help me manage.
Yes.
So let's talk about that. I guess I want to know, so who talk about this general power of attorney and who should have a power of attorney?
Well, everyone should have a power of attorney. As we were saying before we started, I've written power of attorneys for everyone from the age of 18 to 106 at this point. And about 18-year-olds, a lot of times people don't realize that once their kids go off to college, they're adults. And as a result, the only way that they're going to be able to access bank accounts or take care of anything financially for them is with a durable power of attorney.
Okay.
And then, of course, when I first started practicing, the focus was mostly on older people, on seniors. But in my opinion, now everyone should have a financial power of attorney.
And why?
Well, because if you become disabled, then you've got a problem. If you can't handle your own financial affairs, you need to designate someone to do that for you. And a power of attorney is by far the preferable way to do that. If you don't have a power of attorney, what's going to happen is the court would have to then, someone would have to petition the court to appoint a guardian for you. And again, that's a much more expensive, cumbersome court procedure. So again, I would strongly recommend that really everyone have a financial power of attorney in place, again, just in case they need it at some point and they can't handle their own financial affairs.
So in some of the cases that in our discussions that we've had, some of the people are worried that if they get a power of attorney, like myself right now or somebody else, still having full faculties, still going to Florida, coming back, doing their own thing, are worried that somebody who they may have designated as power of attorney and have the rights and privileges of power of attorney would then take over and do things. Clarify that for us.
Well, there are safeguards in that regard. Again, a power of attorney is a very powerful document, but again, you need it to be powerful because you want it to be, every person has different assets and needs, so you want it to be very broad and make sure you're covering everything. We have this old statement called Murphy's Law. If you try to limit something in a power of attorney, that's exactly what you'll need done. So again, I'm a big believer in broad power of attorneys, but you do need to designate the correct agent. I find most agents are honest And the ones, unfortunately, that we read about and the ones that sometimes end up in protective services with Area Agency on Aging are really the very, very small minority. I would say most are family members, trusted family members, spouses and children are the great majority, but there are situations where it is difficult to find an agent because it's a very important position.
Yeah, I mean, we have, adults that either the families are estranged
Yes.
for years, and so they would not feel comfortable asking somebody in the family to be power of attorney. Sometimes I also think about people who are not necessarily close by. Do they really know what the person wants? So in selecting somebody who I might want to be as power of attorney, I want to, as the person looking for somebody, want to know that they're going to understand, in a sense, my thoughts and what I want. Is that
absolutely, absolutely. Okay. Yeah, it's very important to have this dialogue with the person that you're naming as an agent. And again, it is a very responsible position. Going back to your one comment about, well, what if they, what I would call, go rogue or something like that?
Yes.
Every person who's an agent to a power of attorney is required as part of the document to sign what's called an agent's acknowledgement. And they're acknowledging in that they're going to do everything on behalf of the principal, meaning the person who is the individual for whom the agent serves. They've got to always act in their best interest. They've got to always keep a full and accurate record of everything, meaning at least, balance a checkbook or something, and always have to act on that person's behalf. So I find, and perhaps I've been fortunate in this regard, I've had very, very few examples of an individual really doing something improper. So I would not avoid having a power of attorney because there's a fear that, well, they might do this.
Well, I think it's misunderstood as to when does the power of attorney responsibilities begin.
Okay.
I think, and maybe that's why some might be concerned whether they just, once the papers are signed and they can begin, if they can begin doing what they want, are we subject to them dictating what I can do and not do? And so clarify when do we enact, or when are the responsibilities, or maybe two different things?
Well, yeah, there are a couple of different issues there. Number one, the agent begins to act. The agent can act immediately upon the execution of the power of attorney. There's a certain document called a springing power of attorney that only takes place on disability, but frankly, there are a lot of problems that we've had with those types of documents as far as defining disability, things of that nature. So the power of attorney can be acted on immediately. However, in most situations, the power of attorney starts being acted on either when the principal tells the agent, hey, I need you to help me, or it becomes readily apparent to the agent that the principal cannot handle the things themselves. They're in hospital, rehab, or whatever, and they're going to need some help doing that.
Okay. I think of some of the folks that need to be mindful and also watch if they're skeptical in any way of the person enacting some of the responsibilities while the individual can still manage themselves. You want to make sure that you're checking regular accounts and things financially so that that person isn't kind of going behind their back too.
Absolutely.
If there's, I know sometimes there's a family strain and that's kind of the situation most often, and that, as you said, most often that's not happening.
Yeah, it doesn't frequently, but the most difficult thing is probably when the principal has of a mind that I'm still capable of handling my finances, and no other human being would agree with that. And it's very obvious that the person does need financial help. That can, of course, create a strain and a difficult situation. Those are the kind of things where we get calls on those.
Right. And so I kind of, let's look kind of in an order. So if I'm considering that I think I should have, as an adult, somebody that I designate as having the responsibilities of a power of attorney for me, I'm going to consider somebody that I trust, somebody that kind of has an understanding of my thinking and what I would want. And then we decide to draw up these papers that designate this person to be my power of attorney. How do I do that? Do I have to have a lawyer? Is it a legal document? Can I go and get it off the internet?
Okay.
Does it just be notarized? Tell us that
All right.
part of
Well,
that.
I think you probably have an idea what my answer is going to be in this. Yes, you can get it off the internet. I'm old enough to remember when, before the internet, where you went to the book mart up at 6th and Court and bought a form book that do these things yourself. Do-it-yourself wills, do-it-yourself powers of attorney. It's not wise to do that. A very wise mentor of mine told me one time a quote that I'll always remember, and it goes like this: you don't know what you don't know. And you can get a very good form, and there are some decent documents out there on the internet. I will say that. I'll look at some of them and they seem fine. But how do you know that's for you? And unless you have expertise in the particular area, which 99% of people don't, you don't know exactly what you're signing. These documents are not extremely expensive to have an attorney prepare them, so my strong advice is contact an attorney to do it. Also, make sure you're talking to someone that does that type of work. As I tell people, Ann, and I may have mentioned this to you before, I've never done criminal law in my life. And if you commit a crime and come to me, you're going to end up in jail for a long time. But in turn, don't go to the criminal lawyer to do this type of estate planning and elder law work. Or, you know, there are certain things that should be in these documents that a lot of general practitioners don't understand and don't put in. So it's important, as in anything, you know, if you have a heart problem, you don't go to a foot doctor. Same thing. Go to somebody that does this work. So I would strongly recommend, you know, you seek professional help of someone who does this type of work.
Okay. And what typically, can you give me just kind of a quick overview of what is part of the document?
Okay, well, the first thing you're doing is you're stating your name and address, and then you're naming your agents. Now, that comes into play as far as, can there be more than one agent? Yes.
Okay.
And an interesting situation has kind of evolved over the years. Many years ago, we used to put a primary agent and then a secondary agent. But frankly, we've been running into more and more problems with that, with banks and financial advisors, that in cases where you have a nuclear family and everyone's getting along, and you have, let's say, a spouse and 2 children, what we recommend now is naming either or the spouse or the 2 children. That way, let's say spouse is handling things for the infirm spouse, but the spouse handling things is laid up for a period of time. One of the children then can immediately step in and take care of that. Whereas if it's a secondary, we've been having more and more problems, as I said, with the banks, especially the large banks, the financial institutions, and don't want to deal with that type of situation. Now, there's still some where you have to have blended families, things like that, or a spouse and then an outside individual perhaps, that they are going to feel more comfortable just having the spouse first and then the other person as the alternate. But that's the first part. And then you get into all the various powers. I'm not going to get too technical as far as a lot of them, but again, we believe in very broad powers. And one of the broad powers that we do strongly recommend is broad gifting powers. And the reason we do that is so that in the event of an institutionalization of the one spouse, the other spouse, for example, or child, can transfer an asset to the other spouse if the principal is no longer able to sign their name. It's a matter of preservation of assets, nursing home planning, things of that nature.
Okay.
And I find a lot of power of attorneys done by general practitioners do not understand that and don't have that language. Then you're going through, of course, a lot of the usual things, you know, for banking and investments and real estate and insurance, annuities. Also now, there's been a new statute in Pennsylvania just over the last couple of years, because again, the law needs to keep up with the technology. And right now, there's a section on online accounts and digital assets. It's become a problem where you have, and more we find people, of course, keeping their documents and their finances online. Well, that's fine while they're living. But if something happens, or if they're competent,
Yes.
but if they become disabled and don't have knowledge of their passwords, now you have a problem.
Yep.
So you need to get in, and the servicing companies took a very hard line on the privacy end, but now most states have now enacted these statutes where now, you know, you can work with the servicing company to get into the assets and things of that nature. But again, that's a matter of keeping up with the times. And then again, the power of attorney must be signed and must be notarized, and it must be witnessed, I want to stress this too, by 2 what we call disinterested witnesses. So I tease people about being disinterested when they come in to sign. And if you're doing that in your law office, that's fine. But I disagreed with the state legislature, as did the elder law bar, when they did this, because they didn't seem to understand that many of these power of attorneys are not signed in offices. They're signed in hospitals, nursing homes, personal care facilities, people's residences. And as a result, you can't have the people who are the agents being a witness to it. So the attorney, like myself, can take the notary acknowledgement, but you need to find 2 other people. Tomorrow evening, I'm meeting with people down at one of the nursing homes, and I tell them, you got to bring along 2 other people. Because also, most staffs of nursing homes will not allow their people to witness, which I can understand.
Yep.
You can run into some conflicting situations there. And then the end of the document is that agent's acknowledgement I talked about, which lists all the things that the agent is supposed to do and make sure that things are done properly. So in a nutshell, that's a power of attorney.
And it doesn't take, it sounds like it's complicated and long, but it is not, right?
No,
it's
really,
not a difficult
isn't. Yeah, an
situation,
attorney
and
who
both
does
parties
this kind
have
of
to
work.
be there.
Yeah, exactly.
Okay, all righty. Just make an appointment, talk to you,
right. And by the way,
designate
the agents' forms can be sent out to the agents because they don't have to be at the meeting. All I really need is the principal and the 2 witnesses. Because a lot of times children are out of state or whatever, and then we just send the documents, the agent's forms out to the children.
Okay. And then we mentioned earlier about financial. So there is what many of us determine financial and medical and durable. Can you just explain that real quickly?
The word durable is confusing. A lot of people ask that. What durable means is it survives the incapacity of the principal. Believe it or not, early power of attorneys, everything comes of our law in Pennsylvania from English common law. And in the agency law, the best way to describe it to people is, let's say the master tells the servant to take the load of grain to market. If the master would become incapacitated, that agency relationship would stop. And as a result, that came over to law in the United States. And believe it or not, in early power of attorneys, if the person became disabled, it would end. Well, that's precisely what you don't want. You want it to act, you want it to be acting that. So you had to put that magic word durable in. Now, about 30 years ago, that law was finally changed and says that all documents are presumed to be durable. Unless you state otherwise. But, you know, we attorneys are kind of belt and suspender type of people, so we still put unrestricted durable power of attorney on there. But that's the term durable, what it means.
What if, so they have a situation, we've had the document for 10 years, whatever, and either the person that I've designated as my agent has either died or we've moved so separately that I'm not even sure that they want to do this anymore, or somebody says, hey, I've got a lot of personal issues. I really would prefer not to maintain my status with you as your power of attorney. Can I, is it called revoke? Is it changed? How does that work? And can I do that?
Yeah, the normal, and there are different ways you can do it, Ann. The normal way you would do that is just prepare a new document. You just prepare a new power of attorney that will automatically revoke any old powers of attorney. Okay, one of the issues you brought up, I'm going to mention too, was you said 10 years difference. One of the biggest problems, and some of you viewers out there may have run into this if you're serving as an agent for somebody, is different, especially the larger banks now and investment companies, saying your power of attorney is stale, it's too old. Well, that's not the law. A power of attorney, they don't get stale. It's not like bread or something like that. They're still good. However, if you come into one of the big box banks now with a 20-year-old power of attorney, you're going to have some issues with that. So I do recommend to people, even though you don't have to go back and prepare new power of attorneys every few years, I do recommend that when I'm doing other work for them and I see my clients, and if I see that a power of attorney is, let's say, 8, 10 years old or more, I do recommend just updating it. Because again, sometimes there aren't the provisions in that you need to. So you have to kind of outwit sometimes some of the, the control people in some of these banks that they're going to want this, 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 and that. So we're driven by that a lot in today's world, unfortunately.
And in a minute or two, what happens if later on in life, so we're going back to if I don't have the power of attorney, if I haven't had those documents, I'm finding myself not able to understand, comprehend, keeping my own finances, things like that, and I should have had it. Can I get the power of attorney then, or does it have to go into the guardianship
No, as long as
situation?
you have legal capacity,
Okay.
which means you have to understand the document that you're signing, not every single detail of it or anything. Most people don't understand every detail of a legal document they're signing, but you have to have capacity, which means you understand what you're signing. You understand the concept of the power of attorney, that you're naming somebody as an agent. You have to know who they are. You have to have a general idea of your assets and what you have.
Okay.
You can still make a power of attorney, but as you said, Ann, the unfortunate part is people who don't do this and just won't do it want to hang on and think, well, I'm immortal or whatever,
Yeah.
I'm never going to get sick. Then the only alternative is a guardianship. And a guardianship is very, very different. A guardianship is a court proceeding. There are you need testimony saying that the person, a medical testimony from either a medical doctor or a psychologist, psychiatrist, saying that the person is incapable of handling their own affairs. There are court accountings, annual accountings that need to be done. I would say it costs probably 10 times for a guardianship, just strictly cost and fees, what it costs to prepare a power of attorney. Okay. So it's something you really want to avoid. We still run into it here and there, and it's just one of those things.
But it's really best to think ahead
Absolutely.
and get the power of attorney.
And unlike the will and living will, which we'll be talking about, there's no fallback either. If you don't have the POA, that's it. It's a guardianship. Whereas if you don't have a will, the state makes your will for you.
And let's go right
we're
into
gonna go
that. So let's talk about wills. So people get confused too with power of attorney and a will. Clarify the difference for us, and again, then where do I go to draw up a will?
That's a fairly simple one. Power of attorney stops at the time of death. That ends. The will only starts at the time of death. So that's one of the few things in the law you have a clear delineation on that. And again, a will, of course, is a document whereby you designate who you want to receive your assets that pass through your estate, who your assets are, and also who your executors are. Those are the people, the person who will handle the estate, work with the attorney to settle the estate. And then also, I mean, it may have various trusts in the will too. Those are for people who you don't think can either handle the money or on particular disability, or are children, not yet of the age of majority. So you'll put in the will, you'll name somebody as a trustee for somebody else's funds at that point.
So who should have a will?
Everybody. Everybody again should have a will. Well, I'll tell you,
Yeah,
I'll
we're all
say
going to
this,
die,
though.
right?
There are some individuals where every once in a while it's important for me to do a financial and a medical, which we'll be getting to shortly. And really the individual has absolutely no assets whatsoever. So there are certain cases where if you have a will or not, believe it or not, that's probably the least important of the three documents, particularly because of what we call the Intestate Act in Pennsylvania, and that's sort of your default mechanism as far as where
So
you
if I
want
don't
things to
have a
go.
will, then what happens?
The state, think of it as the state makes your will for you in what we call under the Intestate Act. There's an order of inheritance, spouse, children, parents, siblings, etc., on down, and only if you have no relative closer than at least a first cousin would it, then at that point it goes to the state. I always get people who think one of the big misconceptions is, if I don't have a will, does the state take all my money? Well, they may want to, but no, they don't. The state just tells you who is going to get it, and I think I've had that happen once or twice. But again, we got very close a few years ago to a very wealthy individual that it turned out had no relatives. Well, she passed away unexpectedly, and we finally found a first cousin in Rochester, New York, who inherited a couple of $1 million.
Wow.
So again, it is very, very important to have a will in place.
And so on that subject, in another minute or two, if, so my assets and things, explain the difference then, do I need to designate in the will the items that I might have as assets that I have beneficiaries?
That's a very good question, Ann. And this is, again, another common misconception people have. Anything that you have that is either jointly owned, let's say husband and wife, or jointly owned with a child, or you have a designated beneficiary on, passes automatically to that person. It does not pass under your will. And those designations will supersede what is in your will. So again, we have more and more of this as, you know, I know brokers, for example, love TOD, transfer on death accounts. They will supersede your will. And you got to be very careful with that when you're doing that. So when I'm doing estate planning for people, you have to have a knowledge as far as not only what assets they have, but how are they titled and the titling of assets. You know, unless a person is very, very wealthy, we're usually not as interested in the amount of dollars they have as in how they are titled, as to whether they're going to pass under your estate or not. And unfortunately, sometimes what people will do, and not accusing banks or people working at banks of doing anything nefarious here, but sometimes an individual, let's say you have a widow with 3 children, and maybe they don't get along real well, and the so-called helpful bank teller will say, well, you really ought to put one of your kids' names on as a joint owner. Well, guess what? All the money is then going to go to the joint owner, and you better hope then that the other children get along with her, that she's going to share it, or him. So again, you have to be very careful with that when you're looking at that, and make sure you have your non-probate assets, as we call them, meaning the beneficiary designated assets, coordinated with your will.
And to make sure you've always updated those too.
Absolutely.
If there should be a problem
Updating
with that.
is very important. I know we're running down to the end, but I'm going to tell you one quick story about updating. My old friend John had 3 children and a lady friend, and he was a widower, and when John passed away, his children, who were the executors, came into my office, and when I told them that the will said 4 equal shares, 3 children and the lady friend, they were very upset. Well, I didn't hear about this until that day, but it turned out the lady friend, as soon as John got sick, took off with some other guy. And it turns out that the lady friend was going to share 1/4 of the estate. Well, they wanted to contest the will, but I said, well, did John know what he was doing when he wrote the will? I said, sure. I said, well, she's getting 1/4. So keep your will updated is the lesson of that. You have to,
and real quick, in the minute or two we have, we want to just clarify living will.
Yes.
Where does that fit in?
Living will, it's an unfortunate term because people confuse it with wills, but a living will is called, that's a medical document, an advance directive, whereby you are stating that in the event your physicians determine you are in an end-stage medical condition, you're never going to improve, you're never going to get any better, that you're stating, number one, make me comfortable, palliative care, hospice, etc., but don't hook me up to machines to keep me alive artificially. That's the living will. And what we do in Pennsylvania, we have a good document now, I believe, over the last 15 years or so, and we do a combination of healthcare power of attorney, living will. The healthcare power of attorney, of course, is like the financial power of attorney, except you're designating somebody to make healthcare decisions for you. Broad HIPAA powers, the Healthcare Privacy Act, etc. So we put those things together, and it works out pretty well.
Okay. And the living will also, from what I'm understanding, is then you're telling them, again, the measures that you want or not want.
Yes, that's correct.
All right. In the last minute that we have, I guess I would just mainly say to the viewers to make sure that all of these papers, that you've considered this, that you've enacted while you can to get the power of attorney, will, and living will, and that you keep your papers safe, and that others know where those papers are. Those that are power of attorney have their own papers, right, that they're aware of, but at least make sure that those that are going to be helping you know where those papers are so they can get them when needed. So with that, that's the end of our show. I want to thank Bob Kreitz,
it's my pleasure,
elder law attorney, to be here and explain that to us. Appreciate it. And I want to thank you for tuning in to Aging Matters.